He's going to have a break for the next 3 weeks. So we'll have a break from these sessions. We'll probably add something else in during that time to fill in around bold. Because we aren't doing Ignite yet, we're doing a special session of, we're calling it a mini Ignite, with our Monday Jumpstart sessions for those of you that are in coaching. And that way we're making sure between bold, Jumpstart, Contract Camp, you're getting everything you would get in bold pretty much on steroids at the same time. But we don't do bold and Ignite at the same time, because if you were doing both, you'd be totally overwhelmed. And if we do both at the same time, it dilutes people having to choose. So I hope those of you that are on this are enrolled in bold, whether you're new or experienced. And with that, again, welcome to day 2. We are in section F of the purchase contract. Make sure you have a copy of the purchase contract printed out and with you so you can take notes. Stephanie has uploaded it into the chat box. If you don't have a copy and you arrived late, just text into the message box and we'll upload it again so that you can download it to your computer. And with that, Kent, again, I'm so appreciative of you doing this. I am such a snob when it comes to contracts, and I just love hearing you go through the contract. So thank you again, and it's all yours.
Okay, thanks. Thank you, Lisa. So thanks everyone for showing up again. Is anyone new to today's class? You can either maybe unmute and say something if you are. Okay, looks like everyone's a returnee then. That's great. Evan Murakami, is that the Evan that used to work with us at the Ihara team, or is that a different Evan?
Hey, Ken, can you hear me?
Yeah.
Yeah, that's me.
Oh, welcome, Evan. I saw your name the last time.
Oh, thanks. Ken.
Okay, guys. So what we're going to do is, we want participation. Hiroko here is with me in the room, and I want to make sure that we can engage better on the Zoom side. So what we're going to do is, perhaps what I'll do is I'll call out when I'm ready to have somebody else read. I'll call out a name, and then you guys can start reading. Before we do that, let's go really quick around the room. Let's just test it. So you just tell me how long you've been an agent and if you've had any transactions. So let me start with Robert. Robert, how long have you been an agent and how many transactions have you had?
Hey, Ken. Morning or good afternoon. I've been an agent since 2009, but just starting to get active right now. I've only have a few transactions under my belt. So.
Okay, thank you, Robert. Joanne, you're next.
Hi, I've been an agent since May and have 2 transactions.
Wow, congratulations on that. That's awesome.
They're very small, or they were very
That's
small.
okay. That's okay. You're going to learn a lot just, with every transaction. So that's awesome. Okay, Stephanie, you're next.
Stephanie's the VA.
Oh, sorry. Sorry, Stephanie. Chihiro, are you still in? I think someone's in class.
115.
Oh, okay. We'll skip you for now, Chihiro. Jesse, how about you?
I'm pretty new. Officially started in October 1st, licensed since August this year.
Okay. Oh, okay. Yeah, you are fairly new. Okay. How about, is it Zeni? Am I pronouncing that right?
Yes. I got my license about 5 years ago, but just recently activated. And so far it's about 3 months since I'm doing it. No transaction yet, but I'm working with few clients. Hopefully soon.
Excellent. That's great news that you have clients to work with. Okay, Carrie, how about you?
Hi, I've been an agent for like 2 months now, and I don't have any transactions yet.
Okay.
Super
Okay, got it. Yes, okay. How about you, Chelsea?
Hi, I've been an agent 6 years ago, but then I just recently started in 2020. I might have about 4 transactions. I'm not really sure.
Oh, good. Okay, thank you. Anna, I think Anna she was in our class. I mean, she was in person, no? Anna, you're next. She might be busy. Okay, let's move on to Candace.
No, sorry. Sorry.
That's okay. Go ahead, Anna.
Oh, not many. Just the third one just didn't go through. It was an escrow, but the client's back out of it. So not
Okay,
many,
no
not
worries.
enough.
Okay, how long have you been an agent, Anna?
End of 2019, and in this Keller Williams just January this year.
Oh, okay, okay. Well, you've had a few transactions, so that's good. Okay, how about you, Candice?
I came in September to Keller Williams, but my license is still inactive right now, so no transactions yet.
Okay, okay, got it. And then Evan, you got to update me. I don't know what you're up to now.
Oh, yeah, I just recently reactivated my license earlier this year. But I've been licensed since I think 2015. And yeah, just one transaction under my belt.
Okay, are you doing this full-time or part-time, Evan?
Part-time, just representing myself.
Okay, got it, got it. Okay, thanks, Evan. Shauna?
Hi.
Hi, Shauna.
Hi. I've been licensed since September, and I have my first buyer's consult tomorrow.
Oh, congratulations on that. Okay, thanks, Shauna. How about you, Julia? Julia, are you there? Okay, all right. So then let's move on. So what we're going to do is, as we did the last time, we're going to just call on people to read, and we'll go through the transaction, the contract in detail. That we find is the best way to learn it. If all of you can help me, if anyone has a question, go ahead and unmute and say something so that I can hear that there's a question there, or if there's a chat, if people can look for that and then just call out that, hey, there's a question that came up, that would be helpful for me. Okay. Okay, so we finished section or provision F3. So we're going to start from F4. Okay, so F4 is escrow. You're going to have the branch office, email address, all the contact information. So the parties shall provide escrow fully executed copies of this purchase contract and any addenda, amendments, and documents which are required by escrow by the next business day. So if you open escrow today, then you need to get this information, the full contract, to escrow by close of business tomorrow, right? The parties further agree to promptly execute appropriate or customary documents when requested by escrow. So hopefully everyone understands what escrow is, what their role is. You know, we take for granted, I think, that our clients understand who escrow is and what they do. But know that it might be good to be able to explain really quickly when you're going through this contract or through the process, what the functions are of escrow, what the function is of title, so that, you know, they're aware of each entity's role throughout the course of the contract. Okay. Going on to F5, prorations and closing adjustments. Based on a 30-day proration, escrow shall prorate the following, if applicable, as of the date of closing, real property tax, lease rents, interest on assumed obligations, mortgage and other insurance premiums, tenant rents, maintenance, private sewer, marina, and/or association fees. And when applicable, escrow shall charge to seller and credit to buyer the amount of any tenant security deposit. So when you go through closing, you will see on your closing statement, whether you're the buyer or the seller, lines that would show like property taxes or maintenance fees. And typically you're going to see days either credited or days that are charged, right? Depending on if you're the seller, it'll be a credit, because as an example, if you close on the 15th of the month and you own a condo, then, and let's say that there's 12 days left, escrow will take the monthly maintenance fee divided by 30. That's why it says 30-day proration. They'll take, let's say it's $99. So they'll prorate it 30 days. So what is that? $33? No, $3 a day. And then credit back to seller 12 times 3. And then charge buyer 12 times 3. Okay, so that's how you explain it, and that's how you apply it. If you have any questions, go ahead and chime in or raise your hand or chat if you do. Okay. So Hiroko, why don't you?
Can I
Yeah,
chime in a
go
second,
ahead.
Ken? So I know
Of
a number
course.
of them, a number of the agents are starting to learn how to do buyer and seller net sheets. And I really am a proponent of that so that you understand the transaction and so your clients have reasonable expectations. Having said that, if you're using some of the tools online with the title companies, they make no allowances for credits between the two parties, for association fees, taxes, or charges for those. And it can surprise your clients by thousands of dollars, especially in the case where they have their lender requiring impounds for taxes and insurance. It can really sway the numbers a bit. So if you're working on that, just stay cognizant of those credits, and we can always talk about it and find ways, if you're not yet up to speed with the right tools, to do it in terms of how to get that information to your clients. We require a timeline in compliance in command for your escrow. So this isn't a requirement, but I think it's something that you really will have a better grip on how to help your clients, especially if they're doing a sell and buy, if you understand how the money moves between them. So that's all I wanted to chime in. Kent, thank you for giving me the time.
Yep. No problem. Okay, Hiroko, why don't you start reading from F6?
F6, closing costs. The following is a list of customary closing costs, including Hawaii General Excise Tax where applicable, and is not intended to be all-inclusive. Disclosure requirements apply. Buyer and seller are aware that customary closing costs may be reflected differently on the closing disclosure statement, but the net result will be the same. Escrow may change the appropriate party under closing costs as directed by the parties.
Okay, so on there, these are just the customary charges, right? Know that, I think Lisa mentioned that the last time, things can be changed, but this is what is customary. So when you look at charge to buyer, there's a list of customary charges. And then that's on the left-hand side. On the right-hand side, customary charges to seller. So normally when I'm explaining this portion to the buyer, to the seller, if it's the buyer, I'm saying, Mr. Buyer, these are all of your fees. Know that 40%, so the larger of the fees that you see in front of you, one would be title insurance. You're responsible for 40%. Seller's responsible for 60%. Then you have all these other smaller fees. The other larger fee would be escrow, and that's shared 50-50 between you as the buyer and 50% by the seller. So this section here, know that it doesn't include any of the lender costs. These are all just closing costs, and escrow is tracking them. If you wanted a kind of a budgetary number, it's roughly 1% is a budgetary number that I would suggest. Although I think if it's a really expensive property, it'll probably be less than 1%. By the same token, if it's a lower price property, it might be 1 or more. But just to give you a little bit of a guideline.
Are you saying
Any
that?
questions?
Yeah, sorry to interrupt. Are you saying it's 1% for each of them or 1% between them?
Per site. That's correct. Per site. And that's just a very general estimate. So you got to tell them, don't hold me to it. But if they say, well, what does that mean, Ken? How much is that? And I'll say, well, we can get a estimate from escrow, which would be a lot cleaner. But if you were to ask me, generally speaking, what would it be? I'd say roughly 1%, give or take. Okay. All right, Robert, why don't you read F7 for us, please?
Okay, F7, notice on conveyance tax. Pursuant to conveyance tax laws, Chapter 247, Hawaii revised statutes, a higher conveyance tax must be paid if the buyer is ineligible to file county real estate tax. Homeowners exemption on the property tax. 1, declare the buyer's purchasing on the property as the buyer's principal residence as other than buyer's principal residence. The selection changes from the buyer principal residence to than buyer's principal residence. Buyer shall provide written notice to the seller and escrow no later than a certain amount of days or 15 days if left blank. After acceptance date, should the buyer make such changes, buyer shall change at closing amount equal to the difference in the conveyance tax.
Okay, so one is buyer needs to identify what kind of buyer they are. Are they a principal residence buyer, meaning that they're going to live in the property, or are they going to be an investor, which is other than principal residence buyer? So I'm not sure if everyone knows that the conveyance tax that's applied when you're a resident buyer is lower than when you're an investor. And that's why it has in there a note that says, hey, if you're going to change, you got to notify the other side. Mr. Buyer, if you're going to change from a principal resident buyer to an investor buyer, you got to notify the other side. You got to notify the seller because there is a difference in price. Okay, so that's why that disclosure is there with that time frame if you were to change your mind. Okay, any questions on that? Okay, F8 assessments. Let me read that one. So an assessment is defined as any obligation, not including prorations and closing adjustments in paragraph F5. So F5, if you go back to F5, that's prorations and closing adjustments. Okay, so that would be like property taxes, maintenance fees, right? So we're talking about things that are other than F5. So levied, so any obligation levied against the property by a homeowners association, governmental body, or any other entity with a legal right to assess. Assessments, if any, shall be charged as follows. So before we go on, examples of an assessment. So there's several examples when you're talking about condominium purchases, right? It could be, oh, guess what? We need to fix our elevators. We need $2 million to do that. We don't have enough money in our funds to accommodate that. So we're going to special assess everyone. Understand that the association has the legal right to determine these assessments and the legal right to assess all the owners, because their role is to make sure that the building is cared for the good of everyone in the building, right? So that's why they have that authority to assess. Other types of assessments might be spalling or painting, you know, any of these larger type of projects that perhaps the association they didn't budget for, they were caught off guard on. And know that associations, some will be conservative in how they run their association, others will be aggressive. So some will want to collect and hold a lot of money in the pot. Others may not want to collect as much because maybe for them, the less they collect, the less they have to pay, because many times these guys live in the building or are owners of a unit in the building. Okay, so first of all, if there's any under A, any lump sum assessment levied against the property prior to the acceptance date shall be paid by, and you check, right? Either the seller will pay for it or the buyer will pay for it. So typically it's seller that's being checked off if you're writing the offer for the buyer. And then you put down there if there are any exceptions. B would be any assessments levied against the property prior to acceptance, which are being paid in installments. and shall be paid in full either by seller or prorated by escrow as of the closing date, and then any exceptions to that, right? So A, lump sum, B, any installment payments, and then C, what it says here is that if there's any new assessment after you have an accepted contract, that's what C covers. So if a new assessment is authorized against the property between the acceptance date and the closing date, seller shall make appropriate disclosure under I-2. So I-2 is the disclosure section. So now the seller needs to say, hey, this is a new disclosure. I didn't know about it. I just found out about it. I need to disclose it. And such assessment shall be paid as buyer and the seller shall agree, meaning that there's no automatic agreement on this. Both sides have to talk about it and come to an agreement. If buyer and seller cannot reach an agreement within 5 days of both parties being aware of the new assessment, unless buyer has agreed to pay or assume the assessment, either party may elect to terminate this purchase contract pursuant to O3. Okay, so if it's known, then it'll be A or B. Known meaning that, hey, in the budget, in the RR105C disclosure statement, there's something that has already been approved, then it'll fall under A or B. If there's something that's being maybe talked about, maybe just approved, and so it can get a little bit gray for section C, right? That's where seller needs to disclose, buyer needs to review what's been disclosed, and then buyer needs to decide, do I accept it, do I reject it and cancel, or can I go back to the seller and try and negotiate something? Because if an agreement cannot be made within, the time that is given for the new for C, F8C, then either party can cancel. Okay, it can get a little tricky because that's why the condo docs are so important, right? You're trying to find any evidence of those kinds of things happening between the time that you have the documents and whatever foreseeable future time frame that you can kind of look into, right? So it gets a little tricky. That's why you do need to pay attention to the condo docs, not just you, but primarily the buyer, because again, that's their role, their responsibility. You're there to guide them. But that's why it's so important, because these assessments could be big, could be a pretty significant amount of money. Any questions by anyone? Okay. Joanne, why don't you read F9 for us, please?
Consents. Buyer and seller may be required to obtain consents of lessors, homeowner or condominium associations, co-op boards, existing lenders, vendors, or other entities. Buyer or seller shall cooperate and take all reasonable action to obtain such consents.
Okay, so buyer and seller may be required to obtain consent of lessors. I think this is just for the disclosure portion of it. Okay. F10, risk of, so after Joanne, Chihiro, you'll go next, but let me read F10. So risk of loss. Okay. Risk of loss passes to buyer upon closing or buyer's possession of the property, whichever occurs sooner. So on this one, especially when I'm talking to a buyer, I'm pretty conservative. So I read that to them and I say, risk of loss passes to you, buyer, upon closing or buyer's possession of the property, whichever occurs sooner. So the conservative side of me says, if the buyer, prior to closing, wants to take delivery of brand new appliances and have it delivered to the home that they haven't closed on yet, what's the risk, right? Because the buyer may say, Kent, the home is vacant. We're going to close on Friday. I want to have Sears deliver my appliances on Thursday. Is that okay? So the answer is, yeah, that's okay. It's up to the seller to allow you to take those appliances. But just in my mind, a little bit of a risk is if there's a fire after the delivery is made, does the delivery of your stuff imply occupancy, right? So, Lisa, what do you think about that one?
Well, I think you're right, is that the word possession is,
Possession.
you leave some lack of clarity or fuzziness. What's interesting about this is, having practiced in California for years, we actually had a huge wake-up call with risk of loss. So the risk of loss, if anybody remembers the earthquakes in California and the Keller Highlands fire, the Oakland fire, if you had a contract that said the buyer was responsible for taking on risk of loss during the escrow period, which is possible, by the way, and in some commercial contracts that happens, that means the house burns down, the buyer would still have to close escrow, and of course your financing may go away in that situation. So when you get to something like having something delivered, you want to make sure you talk to the BIC or talk to the PB, and we get something in writing. I will tell you, in my experience, 100% of the time, an attorney will tell you not to allow anything to come into the property or to take possession of the property if at all possible, because you could even have, they move, there's a real life case I had in my office. They moved a refrigerator onto a property and a deck collapsed. What if somebody was underneath that deck when it collapsed? You could have a multi-million-dollar lawsuit. And if it's put on the buyer and the buyer doesn't have insurance, then that's going to be a catastrophic loss for that buyer, or a catastrophic lawsuit. So I don't think necessarily that it equates to possession, but we joke about that, is how do you prove something that's unclear? You have two attorneys standing nose to nose, toe to toe, ripping up your $100 bills as fast as they can.
Yeah. And that's, I think, why doing an exercise like this is important, because F10, when you look at it, it looks very innocent. It's one sentence. What's the big deal? It has a consequence if something happens negatively in your transaction. So by positioning this provision with your client, the buyer, you can say, Mr. Buyer, I know you may be tempted later to want to move things in earlier or whatever, but here's what this says, and here's how it leaves you open for some liability. And then what it does is it sets the expectation for the buyer, your client, not to even go down that path and ask. Because one, even though they ask for it and you ask the seller may say no, and that might upset the buyer, because the buyer may say, well, why not? It's vacant. What's the big deal? So to try and avoid some of that, use the contract to your benefit to make sure that buyer understand, or seller, what the liability is. So sometimes it's enough where they're not going to even ask, which will then just make your job a lot easier. Okay. Chihiro, why don't you read 11? Okay. I'm sorry, 11?
F11.
Yeah, 11.
Okay, F11, possession. Seller shall give buyer possession of the property at closing.
Okay, perfect. So we all remember when closing occurs, right? That's when it's recorded, and it's typically the bureau notifying escrow that it is recorded, and then escrow notifying you as the agent, hey, we closed, and then you telling your client, good news, we closed. Okay, Chihiro, why don't you read F12?
Okay, F12, keys to the property. Seller at seller's sole cost and expense shall provide buyer at closing with all existing but at least one set of functioning keys, controls, entry, interior mailbox, pool security, parking area, and or garage door openers. Agree otherwise, all keys, controls, and garage door openers shall be released to buyer only after escrow has verbally notified the parties and or their brokerage firms that closing has occurred. It is strongly recommended that buyer rekey entry door locks and reprogram garage door openers upon change of ownership.
Okay, thank you. So there's a couple of comments that I make to this section. One is, as a listing agent, you're going to be given the keys you're gonna have the keys prior to close, typically, especially if it's vacant. Let's say you live in Mililani and the property that you're selling is in Hawaii Kai. And the agent that you're working with lives in Aiea. The buyer is in town, and when it closes, well, the agent who represents the buyer will have to get, or the lister will have to get the keys to the seller, buyer's agent, and then the buyer buyer's agent has to get the keys to the buyer. You live in Mililani, buyer's agent is in Aiea, closing property is in Hawaii Kai. So the buyer's agent says, hey, Kent, I know we're closing on Friday. Today's Thursday. You mind giving me the keys? Because in that way, I can meet them tomorrow morning. And as soon as I get clearance from title, I'll give them the keys. Or escrow, I'll give them the keys. I would suggest that you don't do that. And you say that whether it is or not, you might say something like it's a company policy that we don't release keys early. Because if between the time that you give the keys to the time that it closes, if something happens to the property, it's just gray again. Is it because the guy you gave the key to early went in there and did something? So don't leave yourself open to something like that, would be my recommendation. The other thing is, with regard to the keys, make sure that you read that bold section that says buyer shall pay all fees and or deposits which may be required for any of these items. So I've had in the past an agent call me and say, Kent, you didn't give me a fob. And I said, well, I don't have to give you a fob. He said, no, it says one set of keys. And I said, well, the key is not owned by the owner of the unit. The key is owned by the building. If you want a key, you go to see the building, you give them a deposit, they'll give you a fob. So understand the nuances of that section, that if there are fobs that require a deposit, seller is entitled to get back those deposits. Okay. So
Hey,
just make
can
sure.
I chime in, Kent, or can I ask you a question? As a BIC, when I review files, I see all kinds of interesting things show up. And I know these agents, especially when they're newer, have been given templates or they've gone to somebody's class. And one of the things I'm seeing, and I know there's a couple people on this call that have done it, at least one, and I think it's a template that somebody's given them, is they put seller to provide, they do this in the inclusions paragraph, to provide two sets of keys, fobs, blah, 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 blah. So, what advice can you give this group in terms of if they're the listing agent receiving that? How would this language change that or not? And what would you advise them as a buyer's agent?
I said as a buyer's agent, it doesn't hurt to say two complete sets of keys as a standard. You just put it in under inclusions, right? Or under, what section is that? Where all the items are listed.
So in other words, if they're putting two sets of fobs, that means the seller is going to pay the deposit, turn them over to the buyer, and the seller is never going to get their deposit back.
Could be, yeah, could be. So as a buyer's agent, I put that in there and be ready to be questioned if there is a deposit on the fob. Because again, it goes back to, Lisa, that anything written in supersedes what's pre-printed, right? So it's
Absolutely.
a little gray. Yeah. And then on the seller side, I delete that because we will give them what we have, and we're obligated to give them one set, but I don't want to have to give two sets. So, if it's a seller's market, you're just going to delete that. Don't even open yourself up to that, would be my suggestion. That sound fair enough?
Absolutely.
Okay, Jesse, why don't you read G1, please?
Preliminary title report. Escrow is instructed to promptly order a preliminary title report on the property for delivery to seller, buyer, and their respective brokerage firms. The preliminary title report will provide a legal description of the property and a listing of the encumbrances on the property that will remain after closing.
Okay, thank you. So, first of all, I think everyone understands that escrow is one entity, title is a different entity. Just because it says title guarantee and they have escrow and they have title doesn't mean that you can't separate those two functions. So in theory, I could have TG escrow and I can have Hawaii title on the same transaction. Escrow is going to order from title, which would then be Hawaii title, a title report. It's just customary that whenever you write offers, it's always using the same title and escrow company. Okay, but they are separate. So when this says escrow is instructed to promptly order a preliminary title report, hopefully that my description gives you a little bit of clarity as to why escrow has to order from title. Because you're thinking, why does escrow have to order? It's the same company, but functionally they're not the same, right? Escrow does one function, title does another function. So when you get into escrow, this is saying escrow order from title a title report and deliver it to everyone. And the title report then would show who the owner is, what are the conditions, what are some of the things that restrict enjoyment of the property. That's what will be shown in the title report. Okay. Any questions on that? Okay. So G2, I'll read that. So G2 title, seller warrants that seller is the owner of the property. So if you're ever working on a listing, strongly recommend you call your favorite escrow officer and you pull a preliminary title report. It's never happened to me. I don't know who it's happened to, but I guarantee you it has happened. That somebody put a property on the market, had a listing agreement signed, and the listing agreement wasn't signed by the authorized seller of the property. I guarantee you it has happened. Okay, so that's how important this title stuff is. One is order it before you list it to make sure it shows who is the owner. That's the only guy that can sign on the listing agreement. So if it's listed as Joe's Trust and you're talking to Joe, you would assume that Joe can sign on behalf of Joe's Trust to sell the property. Bad assumption. Whenever there's a trust, there's going to be somebody who's authorized to act on behalf of the trust. It could be Joe or it could be Sue. So that's why you need to know who owns it and what that entity is and who has authority for that entity to be able to sell the real estate. Okay? Does that make sense, everyone? Let me know if it doesn't. Okay. So, seller agrees to convey the property free and clear of all liens and encumbrances at closing with warranties vesting marketable title by buyer. So the exceptions are, but not limited to, easements, covenants, conditions, restrictions. There's a bunch of things, right, that as a seller, you have no authority over. So I'll pick out a couple. An easement. Okay, so perhaps on your property that you're buying, there's a sewer easement. Well, owner of that property has no authority to say remove the easement. No, that easement is there, and if it's a sewer easement, it's an agreement to allow the city to run that sewer line there, and in there it'll probably say, not only can't you build over it, you can only build 10 feet away from it or 5 feet away from it. So that's an exception. I mean, that property is being sold with that easement and nothing buyer or seller can do about it other than understand what they're buying, right? Covenants. I'll give you another example of that. So covenants, you guys have all heard of ADUs, right? Accessory dwelling units. And so it's the city's attempt to allow homeowners to build an addition and rent it to help ease our limited rental market. And so you're saying, great, there's this nice property in Kahala. It's 12,000 square feet. I have more than enough room to build an ADU. So I'm going to buy this property, add an ADU. I'll live in part of it and I'll rent part of it. Next thing you know, you get your title report information. And in there, it says single dwelling only. no AD, it doesn't say no ADUs allowed, but the language in there, if you read it and you examine it, you'll make the determination, or you should be able to make the determination that you can't do an ADU. So that has limits in terms of what you can do to enjoy using that property, right? But that's another exception. That's part of the covenants for the neighborhood. It's similar for Mililani. It's similar, I think, for many parts of Hawaii Kai. ADUs are not allowed. So nothing that title can do to change that. Not that it's not changeable, but I think it might require a majority of the owners of the neighborhood to allow that change to happen, which probably would never happen. Okay. Any questions on exceptions? Okay, encumbrances to be released at closing shall include but are not limited to any liens, mortgages, agreements of sale, financing, judgment, child support, alimony, mechanics liens, notices of pending pendency action, pendants, I don't know how to pronounce that, subsidy agreements, equity share agreements, buyback provisions, repurchase rights, so on and so forth. So when it says to be released at closing, but not limited to, so you have things such as, I'll give an example, child support, right? We had a property that boyfriend and girlfriend, ex-boyfriend and girlfriend were selling. Girlfriend married, so she's now married, has a property that's under her name, half under her name, the other half with ex-boyfriend. Ex-boyfriend had a very common name, like I'll make it up, right? Michael Smith. So when title searches for things that could affect the ability for title to insure and provide clear title to the buyer, they're going to pull up Michael Smith's name. And they're going to see all instances of Michael Smith. And so Michael Smith popped up in my example, and it says Michael Smith owes child support. So we tell the primary contact for this transaction, the wife or the girlfriend, the ex-girlfriend, hey, Michael shows up as owing child support. So obviously they're not the best of friends anymore. So ex-girlfriend calls ex-boyfriend and says, hey, Michael, I need your social security number. I need to give it to title so that they can confirm that you don't owe child support, so that they can make sure that they can provide clear title to the buyer. Michael says, I'm not going to do that. But that's an example of an encumbrance that these things need to be cleared. And those are the avenues that title will go through to clear, to make sure that it's all clear in order for them to issue insurance and provide assurances that title will be clear once it's closed and buyer will own the property free and clear. Does that make sense? Any questions on that? Okay, B, so who's next? Zenny, why don't you read B and C for us?
B, buyer's review of preliminary title report. If buyer is not satisfied with a preliminary title report, buyer may elect within blank days of buyer's receipt of the preliminary title report to terminate these purchase contracts pursuant to paragraph 02. C.
Okay, great. Pause right there, please. Okay, so this is, I think earlier, our earlier session, I mentioned that this contract is very buyer friendly. There's many ways that the buyer can cancel on the seller. So if you look at that for face value, right, what it's saying is, buyer, once you receive the preliminary title report, you have X amount of days to terminate if you don't like what you see. What it doesn't say is, what are the valid reasons you have to give in order to terminate? All it says is is O2, subject to, pursuant to O2, which is within the time frame. which means that if I put 10 days in there, upon receipt, buyer has 10 days to review and cancel if they want to cancel. Okay, so that's how big of a provision it is. It just gives you buyer another way to get out of the contract if for whatever reason they wanted to cancel. Okay, I'm sorry, Zini, go ahead with C.
I have a question though, Ken. So
Yeah.
we don't have to give them a reason. We can just say, well, according to G2B, my buyer wants to cancel. That's it.
Great question. Anytime you want to cancel, whenever it doesn't require you to give a reason, I would say the less is better. I would say based on G2C or B, I'm sorry, B, buyer elects to cancel this contract pursuant to paragraph 02, period. Don't give them any information beyond that because they're going to try and pick a hole in it, and it could compromise, your ability to cancel based on that provision. So
okay, I see.
Before we go on, Lisa, you have any other comments on that?
No, I'm good.
Okay. All right.
Okay. C, title defects. If buyer elect not to terminate under paragraph G2B, and if the preliminary title report or any other report or any updates to such reports reveal that title cannot be delivered by seller in accordance with paragraph G2A, then seller shall make appropriate disclosure under paragraph I2. The seller shall use reasonable efforts to cure any title defects. If within blank days following receipt of any report title defect, seller is unable to cure such title defects, buyer may elect to purchase the property with such title defects, and the seller shall not be liable to terminate this purchase contract pursuant to paragraph 03.
Okay. So this deals with title defects, right? And so title is doing their research and they determine that they cannot provide free and clear title to the property. This is just saying that seller needs to disclose that. But buyer can still buy it if they want to. I would say that would be a tough one for buyer, but it's up to them. Maybe they know something that you don't know. That's one. Second is if there's a loan involved, you probably will not be able to buy it because I don't think a lender will lend on it if there's a title defect and clear title cannot be conveyed to the buyer. Because on the lender side, they're lending the money, but if you don't pay, they get the property. And if you don't own clear title to the property, then they may not be able to get the property back from you if you don't pay them, right? So I would say it'd be difficult for you to get a loan if clear title cannot be delivered at closing for that property, which means it's probably you have to be a cash buyer to do that, right? Okay, any questions on that?
A heads up that land court, you will have, if you have an issue with title, you're not going to close. Doesn't matter if it's cash. You're just not going to get a recording.
Oh, because it is because everything's based on a judge approving it. That's why, right?
Well, it's a torrent system, right? So the state's guaranteeing the title.
Yeah.
And I always wonder why we even pay title insurance on those. But in any event, that's another discussion. So you've got to be wary if you're. I teach the agents. I don't know how you feel about this, but in my classes, I teach the agents to make sure they know what system the property is recorded in when they write the offer. And especially if it is we talked about this when we started the contract last week, especially if it's recorded in land court or dual system, just start with asking your clients their full name because land court's going to require it anyway. And always follow when you look at HIS, don't look at the tax records for the seller's name. look at the sales history and look at the actual deed, because I find about, I don't know what you see, but I see about 20% of the time the agents are wrong in what they put in the listing, is whether it's regular or land court or dual. So you want to make sure you're putting the correct seller's name, and it'll give you a heads up as to a potential problem. We had a problem with a change of name of a seller, and that was a great case in I2 that the seller couldn't even convey title because they had ID that didn't match up with the name that they took title in, because they had to revert back to using their legal name, and they'd had a driver's license when they took title that had their first and last name switched. And it took that seller about 6 to 8 months to go through legal process to get their name changed and get the deed corrected.
Oh my gosh, yeah. I mean, I can just picture all the steps, all the hoops that that seller had to go through to make those corrections. And it's not fun, because every time for land court, you got to petition the court, right? Anytime there's a change required, especially for like names and those kinds of things, marital names, deaths, whatever it is, you got to petition the court. So it's not as easy as the regular system.
Yeah.
Whew, that must have been fun.
She had to sell a leasehold property at 90,000 twice, the listing agent.
Wow. Okay. Carrie, why don't you read where are we? G3? No. G3?
Yes.
Yeah. G3. Carrie, why don't you read G3?
Cool. Vesting and tenancy. The buyer is the persons or entities which have signed the purchase contract on page 14. Buyer shall provide escrow with buyer's full legal names and marital status for individuals, trust documents, name and type of business entity, etc., and the tenancy by which buyer shall take title within blank days, 15 days if left blank after the acceptance date.
Okay. So when you buy, there are some that when you write the offer, you put John and Sue Smith. You write the offer, you submit it. And then John says, oh, can I put this into my trust? You say, yeah, sure, you can put it into your trust. So that's where, it's make sure it's clear how they want to take title. Are they going to take it as individuals? Are they going to put it in their trust? Not saying that they can't do it later, but if you do it now before closing, it'll be the way that they want it to be. Because if they do it after closing, there's going to be another fee, and you're going to have to open up escrow. They would do it on their own, but there would be more cost involved to do that. Okay. Chelsea, why don't you read H1, please?
H1, no contingency on obtaining cash funds. Buyer represents that there are no contingencies on buyers obtaining the necessary cash, including all deposits, down payment, and closing, including loan costs to buy the property. Total cash funds. Failure by buyer to make the balance of down payment as required by the purchase contract shall constitute as a default.
Okay, hold on right there. So this is where when you're working with buyer, you're asking them, do you have any contingency on your cash funds? Is the money available? You got to make sure you're clear about that, because I'm sure there are some, I've been on the listing side where the buyer is saying, yeah, no contingency. Come to find out the money that they need to pull in is from a IRA account. And they didn't realize how long it would take for the money to come out of the IRA, and they waited too long, so it had to delay closing, right? So ask those questions. Earlier, I said that this contract is very buyer-friendly. When it comes to anything to do with financing or putting in your deposits, that's where the buyer is at risk if they don't perform. Okay, so in big bold, failure by buyer to make the balance of the down payment as required by the purchase contract shall constitute a default. So that's why it's important. If the buyer can come up with the cash at the end and they put in $50,000 into escrow, and they're saying, oh, I can't get the balance of the down payment, then they're in default. Seller can keep their deposits as a result of that. Okay. Go ahead, Chelsea. Why don't you finish reading that?
Okay. A verification of cash funds. Buyer shall provide the items indicated below as evidence that buyer has the total cash funds within blank number of days after the acceptance date. If buyer fails to provide such evidence within the specific time period, seller may elect to terminate this purchase contract pursuant to paragraph 03. If seller is not satisfied with such evidence of cash funds, seller may elect within blank number of days of receipt of such evidence to terminate this purchase contract pursuant to paragraph 02.
Okay, and that would be a bank statement, verification of depository. Okay. So this just says that buyer, you have to show seller evidence that you have the cash and you have these vehicles, a bank statement or verification from a depository financial institution or other. It could be other, it could be, financial planner or something of that sort, right? And that would be based, so whatever you provide, you need to satisfy the seller. So you have X amount of days to do that. Again, if you don't do it, then seller can cancel on you, buyer. But let me go back. I have a question for Lisa. Let me go back. So earlier I said, if you fail to make the balance of your down payment as required by the PC, it shall constitute a default. And I made a comment that a seller can keep your deposits, and maybe that's not correct because it doesn't say 01 default pursuant to paragraph 01. So Lisa, what do you think on that for H1? That first paragraph in bold, that last sentence.
Well, once they've named it, again, it's that $100 rule, right? $100 bills being ripped up.
Yeah,
You want to be in a position that your term default, because just by using the term default, I would argue that it's a termination due to default. It's going to invoke a loss of deposit. If you're the buyer in that situation, you've got so many other reasons to get out that I kind of look at it this way. I've always advised my clients, you may be right, but do you really want to go into all that negative energy? They have, $1,000 in escrow or $2,000, but it's more important when you have these ones. We just had one that put $50,000 in escrow as their initial deposit. So then it gets to be serious money, and it could be serious money for somebody, even $2,000, but we don't even want to go there. And by the way, I lived in a world where if you have a client that says, well, you didn't tell me, and they will turn to you and say, you should have told me, I should have written it as you should have asked, you should have written it. And now it's your $2,000 and you were looking to get 2.5 or 3% of the commission instead of the entire sales price, which the seller's looking at. So you've got to make sure you're doing a buyer consultation, you're clear. I see people run into writing offers way too fast and not asking questions. And I say, well, why is this? And they go, well, because that's the template. So I got a template from my team leader or my former team leader, or I got it. And that's why we really advise against templates and copying of other files to write an offer. And it's why we're doing this class, right? We want you guys to understand the contract and ask the right questions, because every client and every scenario is different.
Absolutely.
So we don't even want to.
It all starts with our understanding before we can even explain to others, right? If we don't understand it, we can't explain it, and we don't know the importance of it if we don't understand
they don't
it.
know, unless this is somebody. And I've never met a seller of a property that doesn't think they know more than most real estate agents. Well, that's not true. Maybe I've met a couple, and they really don't. And buyers, the same thing. So, every one of their purchases is different. So even if they've done it 2 or 3 times, it doesn't mean they've done it 2 or 3 times with this contract and with this property. So you've got to still be asking the right questions and knowing what to point out to them. That's our job.
Yep. Okay, thanks for that, Lisa. Anna, why don't you read H2 up to H2A? Hi, Anna. If you're there, you have to unmute.
This is usually the scrambling for the unmute button.
Yeah, I think so. All right, Anna, we'll come back to you. Candice, why don't you pick up H2 up to A?
Contingency on obtaining cash funds. In reference to the balance of down payment or balance of purchase price, if all cash, buyer's obligation to purchase the property is contingent upon the following: check all that apply. Sale of buyer's property located at, obtaining gift funds, withdraw from investment, withdraw from home equity line of credit or other. Buyer shall provide evidence that is satisfactory to seller of buyer's ability to obtain balance of down payment or balance of purchase price if all cash within blank amount of days after the acceptance date.
Okay. Thank you for that. So let me go back real quick. At the top of H1, please note that it does say choose paragraph H1 or H2. So when you're submitting your offer or working with your buyer on submitting an offer, you need to ask them, for the cash to close on this transaction, do you have any contingencies, H2, or do you have all the cash, H1? And you check the appropriate box. Okay, so it's H1 or H2. So if you have a contingency, you need to check it off and you need to provide information about your ability to get the money from whatever source you're listing there. And so in here it says you need to be able to provide that satisfactory to seller within X days of acceptance. So if it's a HELOC, as an example, the seller may say under withdrawal from home equity line of credit, they may say, is it already established or do you have to apply for one? If it's withdrawal from an investment, they might say, what kind of investment? They might say, show me that you have the amount of money, line of credit on a HELOC available, or the amount of money in your investment, right? So just be prepared to be able to provide that information satisfactory to seller within X amount of days after acceptance. So it's important to let buyer know if there's a contingency, we have to show evidence of that. So be aware, I'm going to ask you for some of this information so that we can prove it to the seller. Okay. Julia, why don't you read B and C for us? Okay. Evan, are you there? If you are, why don't you read B and C?
Yeah. If buyer fails to provide seller with such satisfactory evidence within the specified time period in paragraph H2A, seller may elect to terminate this purchase contract pursuant to paragraph O3. If seller is satisfied with evidence timely provided by buyer in paragraph H2A, but buyer is unable to ultimately deposit the balance of down payment or balance of purchase price, if all cash, into escrow in accordance with paragraph C2, then I, buyer may elect to terminate this purchase contract pursuant to paragraph O2, or if buyer elects not to terminate this purchase contract under paragraph H2CI, then seller may elect to terminate this purchase contract pursuant to paragraph O3.
Okay, thanks, Evan. So B is if buyer fails to provide evidence satisfactory, then seller may terminate. So, you know, you didn't give it the information that the seller wanted to see. They don't trust what was given to them. So they have the ability to cancel. So let's say that under A, you told seller, give me 7 days after acceptance to provide satisfactory evidence to you. So buyer gives that information within 7 days of acceptance. Seller receives the information, looks at it and says, I'm not satisfied with this. I'm going to terminate because I'm not satisfied with it. O3 means within X amount of days after the end of that time frame, which would mean the 7 days, right? So let's say that O3 had 5 days in there. Then it would be the 7 plus the 5. And then at that point, if buyer can't provide any additional information to satisfy seller, the seller can cancel on buyer. Okay. And then C says if seller is satisfied with evidence, but ultimately with evidence only, okay, but is unable to ultimately deposit the balance. So I'm the buyer, I've given seller evidence. Seller says, looks good, I'm happy. but ultimately cannot bring in the cash, then buyer may elect to terminate, because then buyer is saying, you know what, I gave you the evidence, it's there, you accepted it, but you know what, I can't get the money out. Because I can't get the money out, I don't have enough money to close, I'm going to cancel. So they have the right to do that. Or B, if buyer elects not to terminate. So now buyer's going, you know what, the money, I expected it to be there on time. I need more time. I need another 30 days to get this money out. The seller can, and so I'm buyer, I'm saying, I'm not going to terminate because I can get it. I need 30 days. And seller at that point can say yes or no. And seller can elect to terminate if they want to terminate. Make sense? Okay. Hiroko, why don't you read F3? I mean H3, sorry. Read up through past up to A, up to B, sorry, up to B.
H3, financing contingency. Buyer's obligation to purchase a property is contingent upon buyer obtaining the loan described in paragraph C2, mortgage loan. A, if buyer does not obtain a conditional loan commitment letter or is unable to satisfy all conditions of the loan commitment letter within the time period specified in paragraph H4, then buyer may elect to terminate this purchase contract pursuant to paragraph O2.
Okay, so there's a couple of things going on there, right? So buyer, H3 is for the buyer's protection, right? Buyer is saying, I want to buy the property, but I need to get a loan. If I can't get a loan, I cannot buy the property, obviously. Okay, so A says that if you don't get the conditional loan commitment letter, then buyer can cancel. So the lender says initially that, okay, Mr. Buyer, you're qualified, but for whatever reason, when the conditional loan commitment letter is due, typically 10 days prior to close or 15 days prior to close, the lender cannot deliver that. Then the buyer says, well, heck, if they can't give me the loan, I can't buy, I'm going to cancel. Or B, or is unable to satisfy all conditions of the loan commitment letter. So I'll give you an example of that. So buyer is qualified, buyer gets the conditional loan commitment letter. That's 15 days prior to close. And let's say 7 days prior to close, the lender is trying to cross off all the conditions in order to fund the loan, but is unable to cross off all the conditions. Namely, one that I've heard of is employment. So in that case, that example, between conditional and final, buyer lost his job. Lender calls the buyer's employer saying, is Joe Smith still working for you? Employer says, no, Joe Smith was fired. Lender says, Joe Smith has no job, Joe Smith has no loan. Cannot fund the loan. Buyer canceled because could not get the loan. Buyer gets deposits back and just cancels on seller. And that's how it works. Okay, any questions on that? Okay, B, if buyer has met all conditions on the loan commitment letter, but lender fails to fund prior to closing, then buyer may elect to terminate this purchase contract pursuant to O3. I don't know if I have a good example of that, but I've seen where, we have in Hawaii, we have condominiums that some mainland lenders are not very familiar with. So we had a listing where the lender who was on the mainland said that they could lend on it, went down maybe a month into escrow, didn't realize or didn't maybe know or realize or didn't look at it early enough, the condo docs. I got an email from the lender saying, sorry, we cannot lend on this project. And they were out of there. So that's where, buyer couldn't get the loan, even though they're qualified. With the switch lenders, they were able to close. That's where the lender could not perform. So that was bad. That was really bad for the seller's sake, because it just delayed everything. But ultimately, the buyer was able to buy. So it wasn't the buyer, it was the lender, right? C, buyer may waive this financing contingency and purchase the property on an all-cash basis, or II, increase the amount of cash funds in order to satisfy all of lender's requirements for funding the loan. So II, increase the amount of cash in order to satisfy all of lender's requirements for funding the loan. What example would that be? Why would that happen? When would that happen? Anyone have an idea? I'm taking that as a no.
I have an idea.
Yeah. Yeah, what's the idea?
Oh, well, I didn't hear what was said, but one of my clients wanted to buy a 2-bedroom, 2-bath condo, and we found out that the building was considered a condotel, so they had to have 50% down in order to do it. So they couldn't do it.
Yes, that is, I think that's a good one. I've not seen that, but yeah. So increase the amount of cash funds. Yeah, because the lender said, which is the lender's bad, they should have known this after getting the condo docs. But the lender said, hey, I didn't realize it was a condotel and I can't lend on it unless you put down 50% and you only put down 25. So you have to increase by 25% or I won't lend. Then yeah, that's a good example. But Hiroko had probably the most common one in my mind, which would be a low appraisal, right? So let's say your buyer has 3% down, but the appraisal comes in really low, and the debt to income ratio doesn't work anymore, and the buyer then has to come up with more cash. So at that point, buyer says, hey, I still love it. I have a little bit extra cash. It's enough to satisfy the lender's requirements to fund this loan. So I'll increase my cash amount and let's move forward to close. Okay. But perfect answers. Okay, if buyer elects either of these two options, buyer shall promptly provide written notice of such election to seller, together with evidence of buyer's ability to perform prior to the expiration of the time periods stated in H4. So H4 has a bunch of big requirements. Okay. So Joanne, why don't you read H4 for us?
Buyer's obligations. Buyer is obligated to deliver to a seller a pre-qualification which shall state that the buyer is creditworthy based on credit report and is qualified for a mortgage loan by so-and-so, with or without review of income supporting documentation. Buyer is obligated to deliver to seller by blank a conditional loan commitment letter based upon underwriter approval and review of property appraisal, which shall state that the loan has been approved and lender will make the loan under specified conditions no later than blank days prior to closing. Buyer shall deliver to seller written evidence that the buyer has satisfied all conditions specified by lender, except conditions which cannot be satisfied by buyer until closing. Buyer authorizes seller and seller's brokerage firm to contact buyer's lender regarding the status of buyer's mortgage loan.
Okay, thank you. So a lot of things going on there. So this is where, there are I've heard there are templates out there that tell you what the dates are. So templates would probably say for A, maybe 5 days, right? From acceptance, you need to provide either pre-qualification or pre-approval. So if we're representing buyer, we really want a pre-approval letter. Now, it could be a little gray in terms of what's the difference between a pre-approval and a pre-qualification, but generally speaking, if it's a pre-qualification, they may not be pulling credit. Pre-approval, they'll do a lot more due diligence, right? Pull credit, look at tax returns, things of that nature. So if it's a pre-approval, it's, to me, a lot more indicative of buyer's ability to get to qualify for the loan. And then for X amount of days, a conditional commitment loan letter. So normally that's like 10 to 15 days prior to close. And then no later than normally 5 days prior to close, be able to satisfy all the conditions so that lender can fund the loan and then buyer and seller can close. Okay, so if these dates are missed, then seller has the right to cancel. So under H5, seller's right to cancel. Should buyer fail to satisfy any obligation under H2, 3, and or 4 within specified time period, seller may elect to terminate this purchase contract pursuant to all 3. Okay, so again, it's on the ability for seller to cancel on buyer. A lot of it has to do with money. A lot of it has to do with money, or when they need to provide evidence of, or when they have to provide deposits of the money. Okay. And sorry, I didn't mention any breaks. I'm not going to take a break. We'll just go through. If you guys on Zoom have to take a potty break, that's fine. Just do that. And then Hiroko, if you get a, yeah. Okay. Okay. Section I. Robert, did I call you twice?
Not yet, but I can go through it. Section I.
Okay,
So
cool.
there's obligation to disclose.
Yes, yes. Why don't you read up to B?
Sure. Okay, disclosure of material facts pursuant to the revised statute chapter 508D for the sale of a residential real property, which means fee simple or leasehold properties on which the current is situated, 1, from 1 to 4 dwelling units, or 2, a residential condominium or cooperative apartment, the primary use of which is which occupancy as residence, and under a common law, seller is obligated to fully and accurately disclose in writing to the buyer of any facts, defects, or conditions, past or present, that would be expected to measurably affect the value of the property to any reasonable person. A material fact, seller acknowledges and agrees that the disclosures requirements under Chapter 508D are in addition to all other disclosure obligations of the seller required by law relating to the sale of real property.
Hello? Is there some technical difficulties? Or I'm the only one cannot hear?
I can hear now. Is there anybody else that can hear?
I think maybe the
I can
office.
hear you, Robert and Zenny, but I don't see Kent.
Yeah, probably the office.
Yeah,
Okay.
I hear it won't let me even turn my video back on. Very weird.
Good. I thought I did something. Okay, good.
No, I
I
heard you
just
read
got-
everything and then it cut off.
I got a chat. We'll see if you can see Stephanie's. They're having technical issues at the office. I just got a text from Kent that they lost internet. So let's hang on for a few minutes.
It must be break time then.
I was actually in the restroom. I texted Chelsea and said, you know, if he asked for me, I said I'd have an agent let him know I need to run to the restroom. So okay, hang on. Were you going to the bathroom?
Oh, back.
They're
Go
coming.
back.
Yeah, they're already down 2-1. Are they back?
Yeah.
Okay, good.
Can you guys hear me?
Yes.
We're just waiting on camera. But we can keep going. Did Robert finish that?
Yeah, I can. I did, but if you want, I can go through it again.
No, that's
Want me to start over?
no worries. So you covered A, right? The disclosure. I1A, Robert?
Yeah, I
Okay.
covered A all the way up to B.
Okay, so for A, it's just telling you that, you know, chapter or HRS, that's a state law. So they're required to disclose, right? Sellers required to disclose what they know. Who's after Robert? Chihiro? Chihiro, why don't you read B, please? Oh, you know, Chihiro, before you go on, before you start, let me just point out that in here it says that
Yes.
seller needs to disclose all material facts.
Oh, okay, yeah. Seller is obligated to fully and accurate that part.
No, just hold on. Let me
A.
explain that just a little bit.
Oh, okay, sure.
Yeah. So when you're working with buyer, seller is going to provide you with the seller's disclosure statement, and they need to. It's a form that is used to be able to explain to the buyer all material facts of the property, and a material fact is any fact, defect, or condition, past or present, that would be expected to measurably affect the value of the property to a reasonable person. It's kind of vague, but that's what a material fact is. So you got to be aware of that, right? So any fact, defect, condition, past or present, that would be expected to measurably affect the value of the property to a reasonable person. That's a material fact. Okay, so I just want to reinforce that, reiterate that, call attention to that, because that's what a seller's disclosure is all about, material facts. Okay, Chihiro, why don't you continue? Read from B down up until I2.
I1B, mandatory provision of disclosure statement. Unless expect the Hawaii Revised Statute Chapter 548D, no later than blank days, 10 days if left blank, after the acceptance date. Seller shall provide buyer with the disclosure statement, a written statement prepared by seller or at seller's direction, signed and dated by seller within 6 months before or 10 days after the acceptance date. Such disclosure statement shall be prepared in good faith and with due care, and shall disclose all material facts relating to the property that are within the knowledge of control of seller, II, can be observed from visible
accessible areas, or III, are required to be disclosed under Section 508D-4.5 and Section 508D-15 of the Hawaii Revised Statutes. Pursuant to Section 508D-9, in good faith and with due care, includes honesty in fact in the investigation, research, and preparation of the disclosure statement, and may include information on the following.
Okay.
Or continue?
Yeah, no, you can stop there. Thank you.
Okay.
So, yeah, a lot of stuff going on there, right? So one is all material facts. And then earlier, I'm sorry, I didn't mention that under I1A1, it says from 1 to 4 dwelling units, right? So it's for, I think anything above 4 would be considered commercial, and commercial does not have, I don't believe it has the same disclosure requirements as single family or real property, not commercial property. And then under B, right, saying that seller needs to take, you have to do it in good faith, with due care. Disclose all that they know about the property. And that's the key, right? It's what they know about the property. So, and they're gonna have to base it or have information that includes facts based on only seller's personal knowledge, facts provided to seller by governmental agencies and departments. So based on, based on seller's personal knowledge. So if they've lived there, you know, they should know about certain things, and so they should use that knowledge to disclose. There are times when a seller is an investor, may not have ever lived there, may have had a property management company that managed the property. And so as a buyer, they may not have as much information coming from the seller on the disclosure that they would if the seller was an owner occupant. So number 2, facts provided to seller by governmental agencies and departments. So that could be like flood zones, you know, things of that nature, right? 3, existing reports prepared for seller by third-party consultants. So it could be maybe they did something and they had a geologist look and see if there's any issues with maybe slide zones or something of that sort. Maybe a termite inspection report, things of that nature for existing reports. And then 4, facts provided to seller by managing agent, homeowners association, condo. So condo docs would fall within that, right? So the R105C, meeting minutes from the association meetings. Under 3, it could also be perhaps information from a property management company, right? So buyer acknowledges that disclosure statement is not a warranty of any kind pursuant to Chapter 508D. Disclosure statement should not be construed as a substitute for any inspection, professional advice, or warranty that buyer may wish to obtain. Okay, so this is an important section. It's important for the buyer to understand what they're buying. And because there's not always a set way that agents look at and look for information, you know, the more that you know, the more that you investigate, the more you will learn, the better you are able to kind of help the buyer through this process. So in one of the escrows that we got into recently, there was the seller disclosed that there is a setback on the property that we're buying. I looked at the preliminary title report. It didn't say anything about this setback. I called the city. The city, I explained to them what was going on. They referred me to, I think, the traffic division. They confirmed, yes, there is a setback on the plot map. So I explained that to the buyers who are doctors, and I said, I have an architect that is familiar with zoning laws that you can talk to if you like to talk to them. And they said, no, we have friends that are architects, and so we'll consult with them. Bottom line is, from the disclosure, we saw that the seller disclosed there is a setback. We notified buyer, who is the client, of the setback, notified buyer that there could be a potential issue, but we're not experts in this, so it might make sense for you to talk to somebody who's more of an expert, like an architect. They were able to talk to the architect. Architect basically said that setback probably will never happen because it's in a neighborhood and it affects too few people. And for them to do that, it would cost millions of dollars to do, so it may not happen. However, because the setback is there, you may have a problem if you ever wanted to try and build into it, or if there's anything already there, you may have a problem trying to get permits to renovate or to modify or to expand, right? So the disclosure is important. This is helping to explain to the buyer what they're buying and potentially what they can and can't do, right? And unfortunately, it can get pretty complicated. So good agents want to try and know as much as they can. So for the newer agents, I use it as an opportunity to just keep going, heads down, just try and find out as much as you can about the property. One, to help guide your client, but two, just so that you understand what are some of the things that happen. Because this setback thing, I've been doing it, over 10 years now. First time I've ever seen a setback that's not on the title report, and it's only, on the plat map, which I think the plat map that I saw didn't have it. So there was another map somewhere that surfaced, but they're still bound by that setback rules from the city. So bottom line, it can be very complicated. You got to dig in, and hopefully you'll learn a lot more by doing that. Okay, Jesse, why don't you read I-2?
Amended disclosure statement. Pursuant to Chapter 508B, seller is obligated to provide an amended disclosure statement upon later discovered information. If after seller delivers a disclosure statement to buyer and prior to closing, seller becomes aware of information that was not previously disclosed, or that makes any statement in the disclosure statement inaccurate, and said information directly, substantially and adversely affects the value of the property, then seller shall provide an amended disclosure statement to buyer within certain days or 10 days if left blank after the seller's discovery of the non-disclosure of inaccuracy, and in any event, and by no later than 12 noon of the last business day prior to the recorded sale of the property.
Okay, thank you. So seller, you get into escrow, seller provides you with a disclosure statement. You review it, everything looks good. You do the J1 home inspection, everything is good. You pass J1. Let's say you're 30 days into the escrow on a 45-day close. And let's say the water line to the toilet breaks and it damages the flooring. Haven't closed yet, but now the flooring is damaged. That's an example of an amended disclosure statement where now the seller needs to disclose to buyer, hey, the water line broke, affected my flooring. Buyer at that point can cancel if they wanted to. It's a real situation. It happened to me. We weren't selling, we were buying. Seller had to replace the flooring. So good news is buyer wanted to buy and buyer got new flooring because the water line broke and we closed. But that's something that if it happens, That's the right of the buyer, right? Seller is obligated to disclose and take care of the situation. If not, buyer can cancel. Because if seller said, well, I don't have money to fix the floor, then buyer said, well, that's a $10,000 difference in value now because the flooring would cost me 10 grand to change it. So if you don't do that, I'm going to cancel, right? I mean, that's how it could play out. So understand your rights as a buyer if you receive an amended disclosure statement. You do have leverage to negotiate something and not just accept it. Okay. Zenny, why don't you read I3, please? Okay.
I3.
Yes.
Buyer's rights and obligations upon receipt of disclosure statement or amended disclosure statements. Upon receipt of disclosure statements or amended disclosure statements provided pursuant to paragraph I1 or I2, buyer shall provide seller with a written acknowledgement for each within certain blank days after receipt. B, upon receipt of the disclosure statements provided pursuant to paragraph I2, buyer shall have blank days of or 15 days if left blank to examine the disclosure statement or rescind this purchase contract. Rescind this purchase contract. C, upon receipt of the amendment disclosure statements, buyer shall have blank days or 15 days left if left blank to examine the amendment disclosure statements and rescind this purchase contract. Should buyer elect to rescind this purchase contract pursuant to subparagraphs B or C, buyer must give seller or seller's agent written notice of such rescission with the specific time period, and the termination provision of paragraph O2 shall apply.
Okay, so you guys all remember that O2 is within that time frame, right? So if you have 10 days, then you have to rescind or cancel the contract within 10 days. If it's 15 days, then you have to give notice within 15 days. So this is just saying what your rights are when buyer needs to notify and when seller, needs to notify and when buyer needs to make a decision, how long they have to make that decision. Okay. Any questions so far under section I? Okay. I4, buyer's rights and obligations under later discovered inaccurate information. Upon discovery by buyer that the disclosure statement or amended disclosure statement fails to disclose a material fact or contains an inaccurate assertion that directly, substantially, and adversely affects the value of the property, and if buyer was not aware of the foregoing failure or inaccuracy, buyer may elect to rescind this purchase contract within the earlier to occur of 15 days of the discovery by buyer of the failure or inaccuracy, or 15 days of the receipt of an amended disclosure statement correcting the failure or inaccuracy. So it said whatever happens sooner, right? So it says buyer may elect to rescind the purchase contract within the earlier to occur of either you receive the amended disclosure statement or or the discovery by buyer of the failure or inaccuracy. So an example would be they gave you a disclosure statement. You have a 20-day J1. So your 20-day J1, you do your inspection on the 20th day. They gave you the disclosure statement on day 1, and you had a 10-day J1, SRPDS, a 10-day SRPDS review period. So you review that, you like it, you sign off, it's all good. On the 20th day, you do your home inspection. And no, this is a bad example because you're not going to do your home inspection on the last day, but it's for discussion's sake. you do the inspection on the 20th day, and you find something that is a material fact during your inspection, what it's saying is you have 15 days. Okay, so you notify then the seller of that fact. Seller then 5 days later amends the disclosure statement. What this section is saying is you have 15 days either from the discovery of it, so that would have been the 20th day, or 15 days from being notified by seller, which would be the 25th day, whichever is earlier. So then in that case, it would be when you found out about it, right, from the home inspection. Okay. And if buyer elects to rescind, buyer must give seller or seller's agent written notice of such rescission within specified time, and the termination provisions of paragraph 02 shall apply. So 02 is within the time frame. Okay. I-5, buyer's remedies regarding mandatory disclosure statement, seller's disclosure statement. If seller fails to comply with I-1 or I-2, buyer may elect to complete the purchase of this property. When buyer is provided a disclosure statement, documents, or amended disclosure statement, and buyer decides to rescind the purchase contract, buyer shall not be entitled to any damages, but shall be entitled to the return of all deposits. And in such case, buyer's deposits shall be returned immediately. If seller negligently fails to provide the required disclosure statement documents or amended disclosure statement, seller shall be liable to buyer for the amount of actual damages suffered as a result of seller's negligence. A court may also award the prevailing party's attorney's fees, court costs, and administrative fees. Buyer's rights to rescind this purchase contract under paragraph I-3 and I-4 shall not apply after the scheduled closing date. Any action to rescind this purchase contract under I-3 and I-4 shall commence prior to the scheduled closing date. Okay, so it's saying that, buyer can still buy even though seller doesn't provide a disclosure statement. If seller doesn't provide a disclosure statement and there's something big that happens, seller may be liable or shall be liable for the amount of the actual damages. But it also talks about in here, a court may award the prevailing party's attorney's fees. So I guess what this is kind of implying is that if this happens where the seller doesn't provide a disclosure statement and buyer still buys, buyer may be entitled to or shall be entitled to things that seller negligently failed to disclose, but it may require attorneys. And then it goes back to what Lisa said. Two attorneys stand face to face and tear up $100 bills as they talk about it. So, if you ever wanted to buy a property and there's no disclosure, just beware. Okay, so let's go. We'll do one last one and then we'll call it a day. So who last left? Who did I leave off with? Carrie, why don't you just read I-6, A and B.
Okay. General disclosures, paragraphs I-6A through I-6. Is that L or I? Describe general issues which could affect the property. Buyer should make appropriate inquiry regarding these issues as part of buyer's inspection right under paragraph J1. A, governmental and private restrictions disclosure. The property is subject to all applicable federal, state, and county laws, statutes, regulations, codes, ordinances, rules, procedures, restrictions, and requirements, including but not limited to those concerning land use, zoning, building permits and requirements, rebuilding requirements, setbacks, height limitations, lot coverage restrictions, and allowable uses. The property may also be subject to private restrictions, which include the encumbrances described in paragraph G2AI. Private restrictions can cover a wide range of issues, including but not limited to design standards and requirements for permits approvals, setbacks, height limitations, lot coverage restrictions, and allowable uses. licenses and easements, encroachment, common wall, private road, common driveway, and similar agreements, and condominium, cooperative, PUD, subdivision, homeowners, community association, or cluster development related matters, including maintenance fees, assessments, and other charges. B, building permits disclosure. Buyer is aware that many residential properties do not have all building permits as required by county ordinances and or may not have been built according to the plans or building permits issued. Buyer understands there are potential risks in purchasing any property on which unpermitted or non-compliant work has been done. The risks may include, but are not limited to, I, fines, II, discontinues use of the property, III, inability to rebuild, and IV, requirement to remove or rebuild the affected area. All of the above could affect the appraised value and insurability of the property.
Thank you, thank you. So, these are important provisions here explaining what the requirements are to disclose, but also how it affects buyer. Because buyer has to also understand how to review all this information, right? So, perhaps one day there's going to be time where we can go through and I can show you a building permits package and what I look for in that package in order to try and determine is what we're buying visually. We can see the property. Has it all been permitted? Right? Has everything been closed? Has there been anything there that is questionable? So that's kind of what these disclosures are talking about. They're talking about building permits, right? Is it possible that a seller sells a property that had a lanai at one point, and then 20 years ago, friends and family came over and they closed the lanai and they never got a permit for that? Yeah, it's possible. So would that, what you thought was living area, now be considered price per square foot, not living area to a lender because it is not properly permitted? It should be a lanai, thus affecting the appraisal. Yes, that could happen. Could you have a private road to get to the property? Could it be vague as to who's responsible for the private road, maintenance-wise? Could it affect the buyer if they buy into this and it's unclear who is responsible to repave the road? Yeah, all that can happen. So, there's a lot of what ifs, right? There's a lot of things that you need to be aware of and be able to at least know that it's possible and kind of where to look for this information. Yeah, so the disclosures and the due diligence on this section of the contract is really important. So it's 7 minutes to the end of our session. I'm going to just end here in terms of reviewing the contract and leave the last couple of minutes for any questions. Does anyone have any questions that you want to bring up that we can talk about?
Oh, I have a question. Kind of go back all the way to where we started today.
Okay.
Where we put the escrow F4. So we see a lot of listing, and when you see a lot of sellers agent, right? They prefer to use such and such branch.
Okay.
Officer.
Yep.
As from your experience or just in general, how much does it you think it'll affect, like, because it's a really competitive market?
Yeah.
And if you don't put those such as preferred escrow officer, how much does it affect, like what should I say? I don't think it'll be a deal breaker, but if there's like kind of neck to neck competitor.
Okay. So Hiroko's question is, because it's so competitive now, a lot of times, I mean, there is some flexibility on how you fill out the contract. One of which is on the F4, which escrow company and which escrow officer. Her question is, how much does that affect seller's willingness to accept the offer if the escrow officer that you choose and company that you choose is not the one that they recommend on the MLS, right? That's the question. So I would say that, the cleaner there's no real yes or no answer. It just depends. If you're trying to write an offer that is strong and you sense that the seller may accept you, then you're trying to write everything based on what the seller is saying they want. And they may want the escrow officer and the escrow company. Understand that for a lot of the agents out there, the escrow officer and the marketing person for that escrow company supports the agent. They'll do like, joint brokerage stuff, or they'll do a lot of things to help the agent. And so the agent, unofficially, right, the agent is just trying to help out now that escrow company. So for some, yeah, it's important from a relationship standpoint. And others, it may be important because some escrow officers are better than others. So they may say, well, I don't want the one that you want because I don't know them. I know mine, and I know mine is good. So, so I don't have a good answer other than it depends. You have to figure it out with that agent, right? Because some agents don't care, others care more.
Yeah, I understand it's coming from their agent's relationship.
Yeah.
not just,
Yeah.
Because if you feel like you want to work with your escrow officer.
Yes.
Then
Because it's easier, right? If there's a question, you call the escrow officer, you know them, they'll get back to you right away. They may be more willing to do more research than another agent or officer might be willing to do. It's all about relationships.
And especially if you think about protecting your buyer, maybe you just want to just choose whoever you think it's
Yeah.
comfortable.
Yeah, because, how much difference will it make for the buyer? Because normally the buyers, they don't know any escrow officer. They don't really care, right? They don't even understand the importance of the escrow officer. So it's more a matter of you as an agent. I prefer this guy or that guy, not so much the client. Yeah. Any other questions? Okay. Thanks everybody for showing up again. If you guys have any suggestions on how to make the session better, let Lisa know, and we'll try to incorporate that into the session the next time.
Absolutely.
Okay.
And Kent, once again, thank you so much for being here. And gang,
Oh, you're welcome.
next time is in November. I forget the date we have next in November, but watch the calendar. And if you have any questions, let me know.
Yeah, we're gonna have a 3-week break and then I'll be back.
Thanks again. Have a great trip.
Thank you.
Oh, thanks, Lisa. And then you know what? As a result of this, if we want other sessions, like I had mentioned, the building permit package, I'd be happy to do that at some point, later.
That sounds great.
Okay.
Okay, guys, have a great one. Thank you. Thank you.
Thank you. Bye.
Aloha, everybody.